So first, let's look at the CASW code and what it has to say about confidentiality, because the papers that you have are both based in Australia, and that's largely because I found it really hard to find anything that was Canadian that talked about this in much detail, specific to social work. So I decided that the fact that they were social work papers was more important than them being Canadian social work papers. But the thing is, you do need to consider that the laws that govern confidentiality and disclosure are different in different jurisdictions. So you actually do have to look and see what it says in Canada specifically. So if you look in our CASW code in the sections on confidentiality, it talks about confidentiality being a cornerstone of professional social work relationships. And we all know that the relationship is considered very important in social work. And certainly the idea that knowing that you could go to somebody and tell them what's going on in your life and that that's not going to leave the room, it's considered to be an important part of building the trust that's necessary for those relationships. So within the code, it tells us that we have to protect the privacy of information. In the guidelines, it talks about not soliciting information that's not unnecessary for the work we're doing, and that the client has a right to have control over when or whether their information will be shared. Now, of course, we know there are some exceptions to that. Usually the first ones we think of is if there is information available to you about a child being at risk or being harmed. And that's true, though again, this is one of those areas where it can vary from province to province. So it may be interesting for you to look and see what it says in your specific province about which conditions, what kind of circumstances have to be in place for you to actually disclose or for you to report that you think a child is at risk of harm. Ontario, it turns out, has the most stringent regulations, and we do the most reporting in the country. So anyway, that's one of those circumstances. Of course, if you have informed consent, that's another circumstance in which you might be disclosing information, and there's informed consent. And then also, if there was if there was some kind of a law that you had to obey or a court order, when necessary to prevent serious, foreseeable, and imminent harm to clients or others. It was actually educational for me to read that because I thought somewhere in there was an or. I didn't know that it was serious, foreseeable, and imminent harm to clients or others. So consider now that you have to meet all three of those criteria to really feel compelled, to feel that you are compelled to break confidentiality. The other thing the code talks about is that we have to be transparent about circumstances in which we would maybe need to break confidentiality. And of course, many of you will know, especially the practicing social workers, that we're supposed to be discussing the limitations of confidentiality in early meetings with any of our clients. So usually we talk about privacy and confidentiality as if it's just something between the social worker and his or her client. But the reality is there are an awful lot of stakeholders involved in what we do with clients' information. So when we think about what happens with us and our clients, whether that's an individual, family, or group, the things that go on there have an impact on all kinds of other people, and whether they get shared or not is going to affect people like your colleagues, your employer, your profession, other third parties who may feel like they have a right to know that information or may have information about them disclosed, and also the community. And a lot of what your papers make a point about is that when we endanger that trust, when we consider breaking confidentiality, it's not just going to hurt the relationship that we have with our clients, it's going to hurt the relationship we have with the entire community if we are seen as an individual or an agency that doesn't protect the privacy and confidentiality of its clients. And you can also consider that this has an effect and an impact on the profession and its stature as well. So, if we think of the trust in social work relationships, what is the foundation for that? Well, there's a lot of work on Working Alliance that would actually go in a completely different direction. If you are looking at work on the Therapeutic Alliance, it will talk about the trust in social work relationships being based on actually how we interact with each other. The fact that we're able to have agreed goals and agreed ways of working on those goals, and some kind of positive connection. But within this discussion, the focus is on privacy as a foundation for trust and confidentiality. So, in the area of privacy, the idea that a person who is coming to you for help knows that you are not going to interfere in their lives unnecessarily, that you are only going to be asking them what you actually need to know, and that you are going to be protecting them from having other people without their authority having access to their information. And then confidentiality follows from that, in that confidentiality means that they are also protected from unauthorized disclosure of information. So they know you're not going to be taking the information that they have shared with you and discussing it with other people without their knowledge, certainly. But in your paper by Collingsridge, what they say is that the trust argument actually doesn't take us very far. They think that we sort of relax into this idea that trust is foundational to the helping relationship, but the reality is we know that confidentiality has to be broken all the time. And Collingsridge actually questions whether this is an issue. Um, Part of what they raised in that paper is they asked, do we actually know that confidentiality makes clients more trustful? Like, do we actually think that part of why clients feel like they can tell us things is because they believe it's confidential? Which I have to think about because I kind of do think that's true, but they don't. And then, do we think that confidentiality actually makes social work more effective? That sounds like a very difficult question to research, but I'm not sure I could make the argument that the secret ingredient in social work help is confidentiality. And then, to me, most surprising, Collingswood raises the question of whether confidentiality is actually something that practitioners hide behind so that we won't see that they're practicing ineffectively. And I don't think that that there is. I think he's got the order wrong. I don't think that social workers use confidentiality as a way to hide ineffective work, but I do think that sometimes the ineffective work of social workers and other helping professionals may go unrevealed because everything is kept confidential. Yeah, it's an interesting read, that paper. Obviously, there are complications in this idea of confidentiality, and part of what Collingsridge and the other paper want us to know is that it's to say that we have an absolute guarantee of confidentiality within our helping relationships is a huge exaggeration. We know, for example, that most of us work with teams or work in agencies where information is going to be shared to some extent amongst our colleagues. We know that there's legislation that says that we may have to break confidentiality. I've already talked about reporting if there's suspected harm or risk to a child, and I've mentioned that there are jurisdictional variations. And then around this idea of duty to warn, which is based on the Tarasoff decision, which is mentioned in both of your papers, um, the idea that you have to break confidentiality because you believe somebody else might be at harm is actually far more complicated than it seems on the surface. And they talk about some of the variables that you might consider in trying to decide if you have to break confidentiality because of risk of harm to somebody else. But the evaluations that you might make in terms of what level of risk there is for this other person or what degree of harm they may be vulnerable to is highly subjective. And if we go back to that case study that we had back when we were talking about dual relationships, at the time, I suppose some of your thinking was about the fact that this sister could be at risk of being in a relationship with a really bad guy, and she was at least experiencing the harm of having money taken out of her wallet. But it doesn't sound like that actually is the kind of stuff that leads you to a place where you would have a duty to warn. And I've actually provided an additional reading in your portal that's written for counselors, but it isn't the Canadian context and it will tell you more about the duty to warn. So I encourage you to check it out. It's only a couple of pages. Now, in the Swain paper, they suggest that we should forget about this idea of putting out there that everything's confidential except for situation one, two, three. And in some ways, we should just talk about the fact that we're going to try to respect the information that people give us, and that we are going and explain to our clients what it is that we're going to do to guard against the misuse or misdisclosure of their information. In other words, I guess, talk to them instead about who has access to their information, under what circumstances they have access to that information, how things are locked up and kept secure in your agency, etc., etc., etc. He thinks, or maybe it's a she thinks, that that's a more suitable discussion to be having than the often cursory statement that we make to our clients about the limits of confidentiality when we start working with them. In everyday social work, we tend to invade people's privacy, and it's really the privacy of the material that people are sharing with us that leads to concerns about confidentiality. But we invade that privacy all the time because we believe we need to know things in order to help them. We may invade their privacy because we want to prevent harm to clients or to others in the kind of circumstances that have already been discussed. And one that I appreciated somebody mentioned in one of those papers is that we also invade people's privacy in the interests of research. And in that one, in some ways, it's even harder. It's the hardest to defend because we can't say that it's clearly to benefit that client or to prevent harm to other people. So I think the key questions that we want to ask ourselves around privacy and confidentiality is, first of all, what do I actually need to know? Like when I am working with clients, am I very deliberate in my thinking about why I'm asking certain questions and why I'm probing in other areas? It can't just be a fishing expedition, and it can't just be for your own interest. Why do I need to know this? How do I plan to use this information? And then further, what do others need to know? Who are the other people who need to have access to what is this person's private information? Why do they need to have access to that information? What are they going to do about that? What are they going to do with that information? And then finally, how does my answering of those questions about who needs to know and why they need to know, how do they reflect my commitments to respect for persons? Because what Swain suggests, I think it's Swain suggests, is that really it's not so much about it's not so much about confidentiality, and it's not even so much about privacy. Really, what's at stake here is the respect for the people that we work with, and whether or not we are acting in a way that respects that person and their privacy.
Hi everyone, just coming in for a minute to follow up that presentation. It occurred to me that maybe it would have been good to have spent a bit of time talking about the various privacy policies that you might have at your organizations, and that also maybe at the provincial level, FIPA, HIPAA, PIPA, they all have different names, but they're all about privacy. And they asked those questions that I finished up with. You know, who needs to know this information? Why do they need to know that information, and what are they going to do with it? So you will probably encounter that yourselves when you are working in various institutions, and may already have a lot of experience with that you can share, because it can raise some important questions about things that we take for granted in terms of like sharing information. So for this week's case study, I have taken us out of the one-on-one of counseling relationships and into the community, because I think it's important for us to think about ethics at that level. And I know that for your assignments, many of you are considering issues that are more at the organizational and community level, so I think it's good for us to get some practice with discussing those. And privacy and confidentiality is often something that we don't think about at those levels beyond something like a FIPA or HIPAA regulation. The situation that you're going to be looking at is one that emerged out of the sexual assault and beating of Renelle Harper a few years ago in Winnipeg, Manitoba. And you're going to see the press conference that happened a couple of days after. And I have questions for you about decisions that were made around what was disclosed, who disclosed it, why they disclosed it, and how we think about that when we consider our ethics from the perspective of social work, from the perspective of being in social service organizations, from the perspective of who we are as people, and what we might think about what would be ethical and respectful in that situation. I'm really looking forward to the discussion, and I will see you online.